And we conclude tonight with attorney Drexel Bradshaw, who's a seasoned trial attorney with an impressive list of litigation, including in the area of property law, both sides of property law.
Yes.
Tenants.
Good evening.
And landlords, both sides.
Yes, sir.
And of course, in this drama, psychodrama in San Francisco, one side looks at the others as a classic Hollywood version of The Landlord. And then on the other side, the image now, the San Francisco tenant as being the sharpest tenants in the United States who know how to basically extort landlords from tens of thousands of dollars, especially at sale. So two demonizations going on here.
Of course.
Any truth to either one of them?
Some. There's probably truth to both sides. And there's probably a lot of falsehood and misconception on both sides as well.
But in general, you don't think there's a weighting through the law, there's a weighting of advantage to one side or the other?
I think clearly the rent ordinance stacks the advantage in favor of tenants. If it didn't, we would have the equal flow of property back and forth at market rates, and the market would control what those rates would be.
So the logic that the progressives use, that if you let that market go, where do you think the rents would go?
Up, naturally so. Mm-hmm. And that was the whole rationale behind implementing the rent ordinance in the first place. But it was probably well-intentioned, at least at the start, to preserve the diversity of our city. And I don't think there's a true San Franciscan alive who would say that we would want to do anything but preserve diversity in our city.
Mm-hmm. But in reality, when you look around at the city 20, 30 years later, what's happened is the very thing that the progressives and those defending tenants and those of lower income, you're seeing just the opposite occur. It's becoming a city of the rich. The newest buildings being built are for the rich. When people move out, rents do go up to market rents, but they go beyond market rents. So in other words, if a unit becomes vacant, instead of being $1,800 at market rent, if it was an even market, they go to $2,300, $2,200 because they can get that.
Because the market forces of supply and demand are driving that price to whatever price it comes to.
So where do you think, as you look at it, where do you think this is going to go in terms of this battle between landlord and tenant? I guess the answer really is who's winning. It would seem to me that in the end, the landlords are winning in San Francisco.
Well, I think that some recent legislation has made it a little bit easier for landlords to regain possession and then convert rental units into tenancy in common units or sale units that people are then able to own, which of course promotes home ownership, which is an important component as well for us.
And you do those?
Absolutely.
Tenants in common?
Yes.
And so the stories that are used by advocates for tenants, have you seen those stories where elderly people have been thrown out of their houses, the disabled have been thrown out of their apartments, for the sake of wealthy yuppies to be able to buy their own unit?
At the same time, because of Prop H, they recently enacted legislation that increases relocation assistance payments to tenants. Those tenants who are moved out of their apartments after being there for 20 or 30 years
mm-hmm.
are rewarded substantially for doing so.
How much?
Up to $13,500 per unit.
Yeah,
tenant.
but does that make much difference? Over a period of the next 2 to 3 years, that money could go very quickly, couldn't it?
Does it make much difference if a tenant who has been in an apartment since birth for decades and
mm-hmm.
Is paying several $100s a month for a 2-bedroom apartment with a great Bay Bridge view and owns their own building right down the street?
I absolutely agree. I do not understand why they don't have means testing for some of these rent-controlled units as well at the other end. As you know, in New York, I believe that's at $200,000. If you make over $200,000, you don't get rent control. We have so many situations like that in San Francisco, don't you agree?
I do. And there is no means testing, and that would probably be appropriate and helpful to ascertain that we're helping the people that need the help, and we are letting the market take care of the people that can swim for themselves in that market.
I tell the story that I had Gullickson here on the program a couple times. And I just basically went down the line. I said, okay, would you take a means test for $500,000? If someone's making $500,000, would you exempt them from rent control? He would agree to it. I said $1 million. If someone's making $1 million a year, are you willing to take that person and not give them rent control? He would not agree to any means testing. Why do you think why would someone hold that position?
I couldn't speak for Ted. I've known Ted for years, and Ted's a fine man who believes
He's
passionately.
a very passionate, honest human being.
Indeed he is. So why would he take that position?
I don't understand that.
That's consistent with the aims of his organization, and as its executive director, that's his mandate.
What trends do you see right now, or if any, in San Francisco, in the flow of legislation, ordinances, and battle between tenants and landlords? Anything happening out there that's maybe not being reported that you see?
Well, I think some things that have been reported, and not nearly as much as they probably should be, are Supervisor McGoldrick's recently proposed legislation regarding including low-income housing in all new developments of any size, greater than one single unit.
Low income?
Yes.
Not affordable?
Well, we call it affordable.
Yeah, okay, we call it affordable, but it's lower income. Has that passed?
I don't believe so. I believe it's still in committee.
Do you think it will pass?
I'm told that it will.
Now, as I understand that, and this is going to come as a surprise to our viewers, well, why don't you describe what Mr. McGoldrick is proposing for 2-unit buildings?
Well, let's talk about what he was prescribing when he talked about 5-unit buildings, because it makes a bit more sense in that context.
Okay, very good.
So if you're building a housing development of 5 units or more, you are required to mandate 15% of that towards affordable housing. Now he's looking to lower the threshold to 2 units. When you lower that threshold to 2 units, you have to either include affordable housing within the project, or you have to pay what's called an in lieu fee. In lieu of providing affordable housing, you're going to donate some money to the city coffers, and a substantial sum, somewhere between $150,000 to $350,000 per unit.
Cash?
I don't think there's any other way to pay it.
So that's per unit?
Yes, that's per unit.
For both of those units? In other words, you take the complex 2 units, a duplex. It'd be $150,000 for the duplex, or $150,000 for each of those units in the duplex?
It would be $150,000 for the unit in the duplex that was supposed to be affordable housing that you elected not to make affordable.
And isn't this the same Mr. McGoldrick, Supervisor McGoldrick, who actually lowered the inclusionary from 15% to 12% for large developments?
Yes, I'm told that's the same.
Right. In other words, so the large developers have a break in what they have to put into that kitty if they don't build the units. They have to put it into this fund that you were talking about, cash in lieu of.
Correct. And it impacts smaller developers much more so than it would larger developers. Larger developers naturally appear to be the developer that could afford to make those concessions in order to build in San Francisco.
And economies of scale, they have staff, they have architects, they have office space to do their work. They can absorb that in lieu of fee or build the units. Isn't this going to? Isn't that about the end of the line when you go after someone, a small property developer of just 2 units? Don't you, even as an attorney watching all this, have to agree that the system's out of hand? I mean, when are they going to stop? What's going to be next?
I wouldn't begin to postulate what's next for Supervisor McGoldrick. And I think that the effort is probably well-intentioned. And I don't mean to disparage his efforts in any way. I think the methodology is faulty, and I think it presents significant legal challenges when the city tries to enforce this against a small property owner.
The Pacific Legal Foundation, and I talked with one of their attorneys who wrote an article recently, indicated that they believe that they can eventually argue that this whole inclusionary housing, this paying of a fee for affordable housing in order to build your housing, or whether to build those units or to put money in there, is going to be constantly shown to be illegal.
For any size unit
Yes.
development? That's an interesting argument, and I'd be interested in hearing their approach to that.
The problem is they can't find a developer who will become a plaintiff because they know that they would be punished at that wherever they are. Let's say they're Stockton developers, and they want to make a case that they're being forced into some inclusionary situation. They have to have that developer go ahead and become the plaintiff. Well, he won't be able to do business in Stockton ever again, so they can't find developers to do that. But do you think, from your knowledge of the California Constitution, that it could be argued that this is a taking of some kind?
Well, all takings are not unconstitutional.
Indeed.
And I think it's appropriate for the local municipality to regulate development in the way that it sees fit. And they're largely left with broad discretion to do so. Here, though, because of the way the statute is written, if you have a 15% exclusionary number for small developers, if I have 100 units, it's easy and simple and fair to calculate what 15% of that development is. It's 15 units. The statute's written, however, that you have to round up to the next whole number when you're talking about the number of units that you're going to make as affordable housing. When you have a 2-unit development, when you round up, it's now 50%. So you've gone from a 15% threshold to 50%, which gives you serious constitutional problems.
But as I understand, okay, that's hopeful for the small property developer that we were talking about. This taking, and justified taking, does have to have some relationship to what's going on in that development. That's kind of a nexus that's been established by an important case, I think Nolan versus the U.S. Coastal Commission, where they imposed certain kind of easements that had nothing to do with the project, but they were managing to try to attach that on. Where does the city get the right to say, you as a developer are responsible for the lack of affordable housing? Therefore, since there's that connection, you have to pay a fee. I don't understand. I understand it should be done. We have to do something. But I'm wondering, how do they justify that? Doesn't the Pacific Legal Foundation have a point there?
Well, they justify it by talking about 1980 legislative findings by the California legislature, that affordable housing was a primary concern to all Californians.
Okay.
That homeownership is a primary concern to all Californians.
Agreed.
And with those legislative findings in place, you then can attach a rational basis to what the Planning Commission, or what the Board of Supervisors is exacting from developers through the Planning Commission.
I can see how the Planning Commission would have that responsibility. They could be held responsible for not producing affordable housing. But how does a particular developer building something on Rincon Hill have a relationship with the lack of affordable housing in San Francisco?
Because they are providing housing in the next generation to come. The housing that they're developing now is what we will be living in the future. And there is a rational basis, I think, between the statute that's imposed against these developers, particularly the large developers, and affordable housing.
Because they're developing a certain kind of housing, they've made that choice, and therefore they still have a responsibility to build a lower end, more affordable housing?
Well, what's different about allowing developments to proceed if you make a certain amount of park space available?
Yes.
You have a certain amount of public access space or retail space.
Right.
Because those are the development goals that a city has set for itself.
That I understand.
Well, they seem connected to
well,
me in this way.
unfortunately, I don't think the Pacific Legal Foundation is going to find a developer to be able to test it. Drexel, thank you for being with us. Unfortunately, we're out of time.
Thank you so much for having me.
And thank you for joining us. We'll see you next time. For program schedules, post-production notes, and free streaming video of select interviews, visit our website at www.sfunscripted.com.